A human rights lawyer says a proposed anti-terrorism law that could see sweeping restrictions placed on suspected terrorists returning to New Zealand is heavy-handed and appears to be tailor-made for just one man, the so-called bumbling jihadi, Mark Taylor. The Suppression Terrorism Bill would allow the High Court to impose control orders on returning terrorists, and those can include restrictions like a curfew, electronic monitoring, as well as limiting access to mobile phones, the internet and even bank accounts for up to 6 years. Mark Taylor, who has fought for Islamic State in the Middle East, is being held in jail by Kurdish-led forces in Northern Syria. But that could change now that Turkey is battling Kurdish fighters along the border. Human rights lawyer Michael Bott says the proposed law is not only overreaching, but it's an overreaction to a limited problem.
For a start, one needn't even have to be convicted of an offence. And you have these draconian orders put upon you with the threat of imprisonment because of how some other person overseas has labelled you. So there has to be some kind of measure in relation to that, or some kind of tweaking or protection in relation to that, because to have someone travel overseas to be labelled in a certain way, then to face on an interim basis even quite draconian orders that can basically have electronic monitoring involved, can control access to bank accounts, and basically live a normal and free life, on its face seems disproportionate and severe. One's also worried about, for example, the ability for political manipulation by offshore operators. Like I remember the Ahmed Zawi case, where our intel, the SIS in New Zealand, basically assured lawmakers and courts that there was strong evidence of terrorist activity on the part of Mr Zawi, and yet when finally the sunlight was brought to bear on it, there was nothing there at all. He quite easily could be released into the community. So one has learned over time to have little faith or a high degree of scepticism in intel provided by, shall we say, nefarious or draconian regimes.
The level of proof required by a quick read of this bill is the balance of probabilities. Can you put that into context for people listening in terms of how that compares with a criminal trial, for example?
Well, in criminal courts, to essentially found a conviction, normally you have to have proof beyond reasonable doubt, which judges will maintain as being the highest standard known in criminal law. So you have to be so sure that there is very little doubt. And where there is doubt, it must be exercised in favour of the defendant. On the balance of probabilities, it means more likely than not. So it's a substantially lower evidential threshold to meet than beyond reasonable doubt.
Is that appropriate given the level of restrictions that could be applied here? Is it appropriate to have a lesser level of proof?
I would argue no, simply because you've got a penalty if you breach of up to a year's imprisonment. So when you've got a year's imprisonment as a penalty, one would hope that the evidential threshold would be more significant, such as beyond reasonable doubt. Because basically greater than a coin toss plus one is not of great comfort, really.
This would also mean that the hearings, in essence, are, in relative secret. There would be restrictions on publishing the details unless given explicit permission by the court. And I also see that the proposal is that the orders would be handed to the person on their arrival back home. So what does that mean in terms of their legal representation and being present during the course of a hearing like this?
Well, for example, it means that when an interim order is made, so it can be handed to the person upon their arrival, that what's happened is that the order's been made in their absence and there's been no one there to actually represent them and raise relevant questions. And so that creates concerns in itself. One has to ask, why isn't there any lawyer advocate involved at that stage to actually have some kind of vetting? That also raises a significant human rights concern, because you're having a person given an interim order, which if they breach, they're going to run the risk of imprisonment that subjects them to a very draconian regime on the basis of evidence they haven't seen.
Well,
what had a chance to respond to.
Given you have some concerns about this, what are we supposed to do with these people? If not this, what is the answer?
Well, Well, these people, how many people are there? So far I know of one who happens to be a rather ineffective, almost Keystone Cop type chap who's been arrested and spent, some considerable time in Syria in detention. So I don't know much about him. He obviously is a citizen, has a right to come home. He may present a risk. I don't know. And it's appropriate, if that is the case, that he is monitored to a degree. Now, is it appropriate that the degree of monitoring is such as this in this proposed bill? The difficulty is that the road to hell, as people used to say, is paved with good intentions. And in this case here, in relation to one person, is this legislation going to keep us safe? Arguably no, simply because it doesn't capture those people who've actually posed a greater threat to New Zealand security and safety in very recent times in Christchurch, whereas this chap overseas, Mr. Taylor, tailored for that, I suppose, but it's not going to be effective in the long term. It's open to abuse because, as I've said in the past, the intel and the definition of terrorism does change and vary from country to country. So the mere fact you've been convicted of a terrorist activity overseas, for example, shall we say in China or even in Myanmar, it doesn't mean, in fact, that you're actually involved in terrorist activity. That's just something that some autocratic power has labelled you as. So that's not enough.
Is it an overreaction, in your view, to a limited problem?
I would argue yes. I think it overreaches. As I say, one understands the reasons for this, but I think there has to be greater consideration paid to basically natural justice and due process. To basically hand someone an interim order that they haven't had a chance to respond to is I think, unfair and a breach of natural justice.
Human rights lawyer Michael Bott.